Hello, everyone. Good evening, and welcome to Internet Law Review. We are here with the latest motion from acclaimed French actor Jussie Smollett. I think I got that quote correct from Dave Chappelle. Jussie Smollett of Empire, and as we last left the action, for those of you who may forget where we left the story. Mr. Smollett, I'm going to screw it up. Mr. Smollett was, his criminal charges were dropped, and then the city wants this money back, and so we're here on a motion to dismiss. The city would like its money back for the investigation spent investigating this alleged false incident. So we're going to see what Jussie has to say about this wonderful thing. It's only 12 pages long, so not a lot to read. And we're going to read it and see what it has to say because hilarity. Let's get started. Defendant Jussie Smollett, by and through his undersigned counsel, respectfully submits this reply in support of his motion to dismiss Plaintiff of Chicago's complaint for failure to state a claim under Federal Rule of Civil Procedure 12b-6. The City of Chicago seeks to recoup investigative and other costs from Mr. Smollett, despite the fact that all criminal charges against him were dismissed in their entirety and he's presumed innocent under the law. This unprecedented civil case, it's in no way unprecedented, not even close, but thank you for playing. This unprecedented civil case was filed simply because former Chicago Mayor Rahm Emanuel disagreed with Cook County State's Attorney's decision to dismiss the false police report charges against Mr. Smollett. Okay, let me help you and Jussie's counsel with a couple key issues. First, there's a difference in criminal law and civil law and a difference of proof needed. So just because they couldn't prove or haven't been able to prove any criminal wrongdoing doesn't mean there isn't civil liability. For evidence of this, I'd point to perhaps the most famous example of this of all time, the O.J. Simpson issue, where Mr. Simpson was found not guilty by a criminal jury, but was found liable by a civil jury because there are different standards. So whether or not Jussie can be found criminally liable for his alleged complete fabrication of this criminal stuff in no way is relevant to the civil issue. And the idea of the city wanting to get its money back for this kind of thing is not unprecedented. You see this kind of thing where people put themselves at undue risk and the city has to, or the state has to put money to rescue them. You'll see them want their money back for rescue charges. You'll see them want the money back for investigation. So the idea that this is unprecedented is false. The idea that because the criminal charge was dismissed, we can't get civil restitution is false. So basically, in the first two sentences, we've committed all kinds of factual and legal errors. We're only two sentences in to a 12-page paper, and there's already like 3 legal mistakes. Let's continue. Mr. Smollett has always maintained and continues to maintain his innocence. Oh, there's a footnote. Mr. Smollett understands the standard applied in reviewing a motion to dismiss is to presume the allegations in the complaint to be true. Right. That being said, and ensure nothing in his filing is misconstrued, Mr. Smollett disputes any and all assertions that he made a false statement and was not the victim of a crime. Okay. Great. Yet the city claims and purports damages are a vindictive effort to prosecute charges the state attorney pursued and then chose to drop. Again, I'll explain this to his attorneys and to you. Civil is different than criminal. Different burdens of proof. So just because the criminal attorney dropped the case and has not so far charged him with any criminal wrongdoing, although that is yet to be fully adjudicated, in no way is relevant to the civil issue. There are different standards. As an initial matter, the opposition asserts the only two allegedly false statements caused the damage sought in the complaint, namely that Mr. Smollett told the Chicago Police Department officers that he was the victim of a racist and homophobic attack and misdescribed his appearance. Yes, those would be the only false statements. But those are all the statements. Those are all the statements of any note. The only false statements are that you were the victim of a racist and homophobic attack and misdescribing the attacker's appearance. You are correct. But when those are all the statements, who cares? While the complaint also alleges that Mr. Smollett falsely stated that the Osendarios could not have been his attackers, the city does not allege any investigation or other response that resulted from the statement. What? They did a massive investigation. The city asserts the affirmation two statements foreseeably caused 18,036 hours of CPD overtime plus untold hours of non-overtime police work. But the filing of a police report in and of itself does not necessarily necessitate a sprawling investigation. Okay. So let me get this straight. We're upset because the city of Chicago spent a lot of money investigating your racial hate crime. So the filing of a police report in and of itself does not necessitate a sprawling investigation. I suppose that's strictly speaking true. You know, the prosecutorial discretion and the fact that police don't have to investigate anything. Yeah, the fact you file a police report in and of itself doesn't necessitate. We're upset that we spent lots of money investigating the police report. So let me get this straight. You claim that you are the victim of a crime. You, in your footnote, say that this is still true, but you are upset the city actually investigated and took your complaint seriously. That's your complaint? You're upset that they spent 1,836 hours of overtime investigating your complaint and they took you seriously? That's what you're upset about? Wow. As a practical matter, usually result in investigation is the extensive one chose to undertake in this case. That's true. That's true. It usually does not mean an investigation this extensive, but you alleged a massive racial hate crime. You had multiple presidential candidates saying that this represented the new Jim Crow. So yeah, they spent more money and more time than they normally would. Guess what? The police can do that. But they made the apparent mistake of relying on your police report, which was true. Anyway, carrying on. Rather, the filing of a police report enables the police and prosecutors to decide whether and how to investigate. Yes, it does. Yes, it does. And they chose to investigate this. And we're sad about that for some reason. Accordingly, the connection between Mr. Smollett's two statements and the damages the city alleges is too attenuated. Oh, it's too attenuated. There's not proximate cause. I see. So your claim is there's not proximate cause. It's too much distance between him filing the police report and them choosing to investigate. That's just too much of a leap. Okay, fine. Moreover, the city fails to allege Mr. Smollett's false statements with sufficient particularity. Nor did they have to because of notice pleading. They just to make basic notice, which they've done. They don't have to allege sufficient particularity, and you know that. So go away. Similar to the complaint, the city and its opposition fails to identify any allegations that would plausibly show that Mr. Smollett, as opposed to officials at the CPD or the state's attorney's office, caused the city to incur the alleged costs. That is a neat trick. That is a neat trick. Mr. Smollett did not cause the city to incur the costs. It was a decision by the police. Completely arbitrary decision by the police. And what fools they were for actually taking the police report that our client filed seriously and investigating it. They should have done that. The opposition merely restates the complaint's conclusory allegations and circular logic that are fatal to an element of causation necessary to state the count in Clause 1 under the city's false statements ordinance and in Count 2 under the city cost of recovery ordinance. In addition, the opposition betrays the fact the complaint only vaguely identifies the circumstances of the alleged false statements. Yes, because that's the standard in federal complaints. In fact, I don't know Chicago law or Illinois law that well, but I bet it's probably the standard in Illinois too. You typically only have to make pretty basic allegations in your initial complaint. That's how this works. Accordingly, count 1 fails to meet the particularity requirement under Federal Rules of Civil Procedure 9b, not even remotely close. Finally, despite the city opposition's effort to parse distinctions between the recovery available under the statute, count 2 seeks to recover duplicative of count 1. Yes, they're independent causes of action. Whether or not they can independently recover both is a perfectly legitimate issue. Normally, you can only get damages once. So if I have 5 different theories I can recover from you under, then each of them are independent, but I can only in total get my damages once. So yes, count 1 and count 2 are duplicative of each other. Is that a problem? Nope, not even remotely close. The court is not bound to accept as true thoroughbred recitals of elements of cause of action, so reported by merely conclusory statements. It is insufficient for a plaintiff seriously to allege that it sustained damage as a consequence of alleged false reports. The complaint does allege the plaintiffs have sustained damages as a consequence of false reports, but that's a legal conclusion about proximate cause, and that's insufficient to state a claim. Well, proximate cause would be one of the standards of, you're looking for duty, you're looking for actual cause, you're looking for proximate cause, and you're looking for damages. Here the complaint and opposition only allege bare legal conclusions of proximate cause, which are insufficient to state a claim. No, not even remotely close, but no, thank you for playing. In its opposition, the city contends Mr. Smollett approximately caused the city to incur 1,836 hours of CPD overtime, plus untold hours of non-overtime police work, because Mr. Smollett allegedly made 2 false statements in the initial report to the police. Yes, those false statements being, the attack happened, and here are the people who did it. Those are kind of material. They're not what we would consider in law to be ancillary. You can definitely make false statements that are not particularly material. And, I was wearing a blue shirt that day, and when you were really wearing a red shirt that day. Now, I don't know why you're lying about that, but does that really, in the grand scheme, matter? No. But if your false statement is, the attack occurred, that's kind of a big deal. For count 1, under the FSO, a defendant is answerable for the natural, ordinary, and reasonable consequences of a conduct, though not for anything beyond that. Yes, and this is not in any way foreseeable. Proximate cause is not established where actions occur that are not foreseeable in the normal cause of events, or independent or far removed from the defendant's conduct. Again, let's get this straight. His attorneys are saying that it was not foreseeable that because he filed a police report saying that there was a racial hate crime, it was not foreseeable the police would actually take it seriously, actually investigate, attempt to find the bad guys, and bring justice to this apparently atrocious racial hate attack. That was in no way foreseeable in the normal course of events. No reasonable person could possibly foresee that filing a complaint saying a bunch of people yelling, "This is MAGA country," and putting a noose over someone's neck, no one could possibly foresee the police would actually investigate that and take it seriously. I've been wrong all this time. I totally see the attorney's points. We should definitely just dismiss this completely. Wow. As noted above, the complaint does not suggest or allege the investigation was an ordinary and reasonable consequence. The opposition attempts to remedy this omission by asserting the entire purpose of reporting a crime is to enable the police to investigate. But this this is like one of those times as an attorney where I get really, really irritated when people do this to me, and it just really is a way to get under my skin. I can see myself doing this, and they're like, okay, so I wrote the entire purpose of reporting the crime is to enable. All right, I wrote that. Is that strictly the best possible wording? Probably not. It's probably not the best possible choice. Maybe I could have put a potential alternative word there. That really wasn't, because of course the police aren't able to investigate a crime regardless of a police report. So, or regardless of report, they can investigate a crime, notwithstanding someone making a point of reporting it. So that's not to enable. So strictly speaking, that's wrong. But I hate it when people do this to me. They like take this little thing and they emphasize it like it's the end of the world. Oh, Kurt Mueller said it's to enable. Didn't you see what he said? He wrote enable. Oh, that's not true. That's not true. The cops, that's not what enables the police to investigate. What enables the police to investigate is statutes that give them the authority to investigate. It's not like because he filed this police report, that's what enabled. Ha ha ha, you silly person, you wrote the word enabled. And that's where I want to just beat you to death with your hands. Because you are taking this thing and you are stretching it beyond all meaning. Unbelievable. This happens to me sometimes. It just gets under my skin. Anyways. But this supposition betrays the reality of the situation. A police report alone does not cause a CPD investigation, nor does it cause the city to incur costs. Yeah, see what they're doing here? This really... Man, if this offends me on a level, because I, as the city's attorney, wrote the word enable. That doesn't enable, you silly person. Therefore, we get off completely. Because you chose a slightly than other ideal word choice. Mason, a case cited by the city, fails to support the city's assertions. In that case, the city found it was natural, ordinary, and reasonable consequence of defendant's payment of bribes to healthcare providers, that those providers would file false claims seeking reimbursement because the defendant was alleged to have been well aware that healthcare providers receiving bribes and kickback would do exactly that and file claims for reimbursement with the federal government. Whatever. I don't know that it's necessarily obvious that if I'm paying you a bribe, that it's foreseeable that you would file a claim for reimbursement. I'm not so sure that strikes me as something that is a foreseeable consequence or obviously foreseeable. Anyways, carrying on, by contrast in the present case as the motionity, the city has failed to allege that Mr. Smollett was similarly well aware his statements to police would result in this overtime. Yes. So, for the record, apparently, Mr. Smollett's position is alleged victims of racial hate crime should not be taken seriously. Apparently, that's the position. Mr. Smollett has taken the position, apparently, that someone who says, I'm the victim of racial hate crime should not be taken seriously. What the police did was investigate. What the police should have done was buried it in a drawer. The police were foolish to investigate that. In the future, stop taking victims of hate crime seriously. Apparently, that's the position Mr. Smollett wants to adopt. It's completely unforeseeable, and no one could possibly be well aware that someone who says, I was attacked at 2 a.m. by someone who attempted to lynch me by putting a rope around my neck and beat me up yelling, this is MAGA country. There was no way I could be aware this would result in investigation. And you're foolish to do so, and in the future, you shouldn't take us seriously. I'm offended by this on levels. I suppose also next time that someone files a notice of a racial hate crime, and that city says, oh, we're not going to investigate it, that person will say, you know what, that's completely reasonable. Because Jussie said you weren't supposed to investigate my crime. I don't know why I bothered filing. You shouldn't take my stuff seriously. That sounds like, it sounds like the kind of thing that, for example, Al Sharpton is going to get on the news about at some point. And he's, there's going to be a person who's going to file a notice of a racial hate crime. And the city's going to do nothing about it. And Al Sharpton's going to get on the news and say, yeah, they shouldn't investigate that. They shouldn't take hate crime seriously. That seems like the kind of thing that, someone who believes in civil rights might say. I wonder also, just incidentally, if we're supposed to take rape seriously or not. Maybe that's also the kind of thing that it would not be foreseeable for the police to actually investigate. Maybe we shouldn't take those seriously either. I don't know. Does he have an opinion on that? Carrying on. For the overtime costs, the city misunderstands the significance of the authority cited in the memorandum of the motion to dismiss. People versus someone supports the proposition the police department's overtime expenditures are extraordinary and thus not foreseeable in the normal course of events. This is a normal course of events. Someone yelling, "This is MAGA country," and putting noose in someone's neck at 2 a.m. in Chicago. Overtime hours are not foreseeable occurrence. Recognizing overtime may be regularly scheduled, though is irregularly and unforeseeable. Okay. A CPD overtime alleged here is particularly unforeseeable. The CPD overtime alleged here is particularly unforeseeable. I'm just going to give us a moment to just digest that together. Indeed, nothing from the alleged false statements that precede the investigation allows for a reasonable inference to be drawn that CPD overtime was foreseeable, ordinary consequence of the statements. Nor does the complaint allege other facts or draw the conclusion that CPD overtime was foreseeable. The city simply concludes, given these facts, it's reasonably foreseeable. Police would investigate thoroughly and would incur overtime costs. This cursory assertion of proximate cause is a legal conclusion that's insufficient to state a claim. Okay. Accordingly, the city's claim in count 1 should be dismissed. Just in case you're interested, we're now 30 minutes into this, and we're just now on page 6 of 12. That's how absurd. This is how deeply packed with crazy absurdity this is. We're a half hour in, and we're on page 6 of 12. Let us continue into the depth together. Don't worry, Andy. We've got plenty of time. We're not going anywhere, it seems. With regard to count 2, under the CR, the city fails to plausibly plead that Mr. Smollett's statements directly caused the costs the city incurred, and such costs were necessary services reasonably related to the investigation. The city must show a causal link between the statements and the costs incurred to sufficiently plead causation. Okay. Friends, I ask you, what is the causal link between filing a police report and the police investigating? Can you think of a causal link between filing a police report and a police investigating? Can you think of any way that those two events might be linked? There might be a causal link between the two, one caused the other. Filing a police report, investigating the crime. Is there a causal link between those two? Okay, carrying on. Yet the city's complaint only presents threadbare, conclusory allegations regarding causation. The opposition only highlights the deficiency in its attempt to rehabilitate the city's position. The complaint alleges that because defendants' false statements, the city expended significant resources solely due to the false statements. Well, it's pretty reasonable that but for the complaint, they wouldn't have investigated it. Because they wouldn't have been aware of the crime because there wasn't one. But for the complaint being filed, none of this would have happened. So not only is it the proximate cause, it's the sole cause. Yeah. The city attempts to recast this in the opposition, arguing Mr. Smollett's allegedly false statements directly and inevitably caused the city to incur significant expenses. But this complaint does not plead Mr. Smollett's directly and inevitably cause the city to incur expenses, nor could it, since investigations are discretionary functions of police departments. Again, the police made a critical mistake here. They actually investigated the crime. Don't you know that police don't have to investigate crimes? Aren't you aware of DC versus Warren and Castle Rock versus Gonzalez and other things that say the police have no duty to the individual? Aren't you aware that a person saying, someone put a noose around my neck and beat me up, yelling, "This is MAGA country," aren't you aware that that kind of language, which in no way is inflammatory, to actually investigate that is foolish. Foolish, I say. Therefore, the city cannot plausibly claim the CPD's extensive investigation directly or inevitably resulted from the statements. Yes, because if they let's all move into our minds in a counterfactual universe. So let's imagine a counterfactual universe where Mr. Smollett made this police report and the Chicago police actually did nothing about it. Do you think in any way that Mr. Smollett would be upset about that? Do you think in any way that if the Chicago police said, yeah, that's interesting, we just can't be bothered, do you think in any way that that might have potentially incurred some sort of invective for Mr. Smollett? What do you think, guys? If the Chicago police said, oh, let me get this straight, you're saying 2 a.m. in the morning, someone put a noose around your neck and tried to beat you up, yelling racial and homophobic slurs. Yeah, we just can't be bothered. We're just not interested, but thanks for letting us know. And Mr. Smollett would say, that seems like a perfectly reasonable choice. I respect that. Does that strike you as a series of events that would have occurred in this counterfactual universe? Apparently, to Mr. Smollett, it's what should have occurred, I guess. Nonetheless, the city continues on the false premise to argue it sufficiently alleges that its services investigating the purported fake crime and costs were natural and obvious consequence of the statements. This argument fails too because the city did not plead that the investigation's resulting costs, including overtime, were natural and obvious consequence of the statements. I mean, how much do you want? I mean, there's a lot of things in law where you have to really lay things down in breadcrumb fashion. There are a lot of things where it's not obvious, and you have to really lay things out in a real chain of carefully laid breadcrumbs to get you from one to the other. And you got to really walk people through it one step at a time. And it's something that doesn't really strike you as obvious. It'd be like my entire argument is dude, really? It seems pretty obvious on its face to me. What do you want? Yeah, I could go get a fifth grader and ask them. Reading the complaint and opposition together, it's unclear where and whom the alleged false statements were made, which is fatal to a fraud claim. A successful common law fraud claim must allege with specificity and particularity what misrepresentations were made, when they were made, who made the representations, and to whom they were made. The opposition illustrates that the complaint lacks the particularized information about the city's claim required to enable Mr. Smollett to understand it and effectively prepare a responsive pleading and overall defense. And Mr. Smollett apparently has problems understanding things. He has problems understanding why a police report would cause the city to investigate. So I guess it is natural that they would fail to understand this. Mr. Smollett's defense is he's an idiot. The ambiguity in the city's fraud allegations renders it impossible to ascertain how a false statement it contends Mr. Smollett has made. Well, you said he made two, one of which being that the crime happened, which prevents Mr. Smollett from understanding and effectively responding and preparing a defense. The opposition underscores the problematic lack of particularized information in the complaint. First, as to where the statements occur, the city states that the defendant made some of the misrepresentations at defendant's apartment. Again, this is if I were the city's attorney and I wrote this and I read this, my natural reaction is I want to beat you to death. You are picking at my words in a way that's completely disingenuous. It does not identify which statements were made at the apartment, where any other statements were made. Second, the city now asserts defendant told responding officers and subsequent investigating officers that he was the victim of a racist and homophobic attack. Notwithstanding the citations, the city complaint makes no distinction between responding officers and investigating officers. Rather, it simply states defendant told CPD officers he's the victim of an attack. I don't know why you have to make a distinction. You told officers. In other words, you told agents of the city. Why does it matter whether they're responding officers or investigating officers? If you made misrepresentations to the agents, they're all the same. The opposition thus suggests a different story than the complaint. The complaint alleges that Mr. Smollett made one false statement to the officers that he was the victim of an attack. Once again, that's kind of a critical false statement in this narrative. The opposition suggests the complaint actually made two false statements. First, the responding officers, and then the subsequent investigating officers. Which is it? Yes, because it's not fraud if you only make one statement. It's only fraud if you make two statements. So that's ambiguity for you right there, guys. I mean, wow. This is brilliant lawyering. Wow. The city cites two additional cases for the proposition it is sufficiently identified the individuals to whom the alleged false statements were made for the purposes of Rule 9 by stating they were made to CPD officers. I would tend to agree. That is sufficient. You made them to officers of the police department. They're agents of the city. A statement to one agent is just as good as another. Carrying on, in both these cases, however, the complaint specifically identified a small group of individuals to whom the statements were made. For instance, in one case, the complaint specifically identified the statements as issued as being made to plaintiff, a small limited liability company with only one member, meaning the universe of specific individuals to whom representations were made is relatively limited. And thus, the complaint gives defendants adequate notice under the rule for the nature of the claim stated against them. You know what this basically says. In case you need me to interpret it for you, Jussie Smollett, made so many statements to so many different officers. I don't remember who I talked to, and of course, because all my statements were true, it doesn't really matter who I talked to because hey, telling the truth to one person is just as good as telling the truth to the other one. So, and it doesn't really matter who I told them the statements to because they're all true. I mean, it would only matter if they're false, but of course they're not. One of the problems with telling lies is you have to keep track of your lies. Yeah, that's basically that's a complaint. I can't keep track of all the lies I made. Similarly, in a different case, it was readily apparent from the complaint that all the alleged false statements were made to one of six people identified, that three plaintiffs and their respective agents, which the court found to be suspicious because it does not require surgical precision. By contrast, in this case, for two of the three alleged false statements, the statements merely said they were made to CPD officers, which far from the relatively limited universe of individuals could include anyone in 10,000-person urban police department. Don't worry about it. You'll get all that wonderful stuff in discovery, and you'll have every opportunity to investigate them. It's more than enough to move forward. And for the third allegedly false statement, the city fails to provide any identification whatsoever who it was made to. Unlike the case law relied on opposition to whom the alleged false statements were made is also necessary here because the city seeks a civil penalty for each alleged false statement. The city fails to plead the alleged false statements with particularity because it ambiguously identifies who Mr. Smollett made the alleged false statements. The people of Illinois. As disclosed above, the complaint articulates these three alleged false statements, yet the city goes on to repeatedly allege the defendant made numerous false statements. Again, this is where I want to beat you to death. I say numerous, and you really want to attack me on the fact I said numerous. That's what you want to like. You want to pick apart my entire legal theory because I said numerous. Really? That's what you want to do? Does the phrase grasping at straws mean anything to anybody? The city also asserts that Mr. Smollett reported fabricated details about the heinous attack to police several times. Well, that could be anything. Either the city contends three statements to be numerous, well, that is a number, or the complaint fails to adequately plead all the statements at issue. The opposition distinction between responding officers and investigating officers, in reference to numerous statements in several reports, shows the complaint fails to adequately plead the instances of alleged false statements with particularity. Yeah, we don't know who we told our lies to. We can't keep it straight. Rule 9b protects Mr. Smollett from the need to divine the particularly alleged fraudulent statements or to draw them out from the city in motion practice. Count 2 is predicated on the success of Count 1 and seeks to recover costs in the relief under Count 1. The CRO thus claims double recovery of compensation costs, which violates public policy. Okay, you finally say something that actually constitutes a legal argument. Congratulations. We're on page 10 of 12, and you've actually said something that's reasonable. Thank you for finally saying something that's reasonable. And you might actually be right. Okay? Normally, you can only recover once. You can only recover once for damages. Like a classic example being, let's suppose I'm in an automobile accident with you and it's your fault. Okay? Normally, I could sue you directly, or I could file a claim with your insurance company, or I can file a claim with my own insurance company if I have coverage for you. So I have coverage both for my own accidents and some accidents caused to me. If you cause injury to me, I have three options. I can sue you directly. I can file a claim with your insurance company. I can file a claim with my insurance company. So I have three potential causes of action. I can only recover once. Now, I can actually seek all three. I can seek all three simultaneously, but I can only get the money once. So that actually is a valid point. You may only be able to get this money once. Does that mean that you can't make multiple counts at the same time? It absolutely does not. You have multiple independent counts. No problem. The city argues it's premature the pleading statement to determine whether count 2 seeks an impermissible double recovery. Yeah, that's an issue for the ultimate remedy. In that case, the court found it was premature to dismiss because there's only a possibility state law claims recover the same costs. The court's reasoning, however, would be appropriate to dismiss state law claims when it became evident that there's double recovery. There's also no reason to decide this issue now. It's totally irrelevant. It only is an issue if you win under both claims. It's only an issue if you win under both claims. And then we'll have to figure it out then. There's no reason to make this decision now. So you might be legally right. There's just no reason to make this decision now. There's no question count 2 seeks to recover the same costs. That's not necessarily a problem. Both claims seek to recover the costs incurred by the investigation. Count 1 seeks treble damages, which means times 3, in amount to be proven at trial, incurred by the city because of the false statements. Count 2 seeks in order for defendant to pay the city's costs at an amount to be proven at trial. Despite the difference in verbiage, both counts seek to recover the costs for the trial by the false statements. Is this a legal problem? No, it's not. You can do that. You can ask for the same thing multiple times. Here's another fact. That's not relevant to this. Federal law in federal practice recognizes mutually inconsistent pleadings. So it's possible and totally legal for me to make multiple allegations that are mutually inconsistent with each other. I can do that. I can say something like, count 1, you hit me. Count 2, you didn't hit me, but I still win anyway. Does the fact that I just made two completely inconsistent arguments a problem? No, it's not. Mutually inconsistent pleading is allowed by federal law. Consequently, as evidence, now the costs sought under count 2 are duplicative. Because it's present seek to, count 2 should be dismissed. No, screw you. Whereas for all the foregoing reasons, defendant Jussie Smollett or Jussie Smollett respectfully requests this court enter an order granting the motion to dismiss with an entirety, with prejudice and blah, 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 whatever. I don't care. Okay, so that is all the crap. So 12 pages of crap. It makes legal errors in almost every single sentence. And they only have one good point, and the one good point they have is not an issue that's ripe. Because we haven't gotten that far yet. So let's just respond to the many, many comments because there were a lot of them, and I want to respond to it. Yeah, F. Pearson. You shouldn't have done an investigation of the crime I asked you to investigate. Apparently that's what we're arguing. Right, Sean Hoagland. Can you imagine the media tour if the police didn't investigate? That's what I'm saying. Let's go to the counterfactual and assume that they didn't investigate. And Jussie would say, well, that's totally reasonable. The police don't have to investigate. That sounds totally like a thing that would happen. Motion to dismiss is saying even if the other guys, it still doesn't make me liable. Yes. Motion to dismiss is even if everything they say is true, I still win. Because they don't have a legal theory. This is 12b-6, which is failure to state a claim. So in this case, it's motion to dismiss for failure to state a claim. Means if every single fact they say is true, I still win. You don't win. Without reading the complaint, I feel like this whole motion is boned from the outset. I feel like it's boned from the outset too. I read the complaint and I know it's crap because it doesn't make any sense. Feel the counsel's just throwing this out just to say they did? Well, hey, it's another way to bill your client. And I guess, I mean, when you are absolutely like dead to rights, guilty and liable, all you can do is gasp at straws, I guess. So, I mean, you got to do something. So, good for trying. I'm starting, Altria Mungara says, I'm starting to wonder if Smollett was thinking all police are racist and thus won't bother to investigate a crime against a black man. It's hard to believe that he genuinely thought that someone saying this is MAGA country with a noose around my neck and being beat up while they're yelling homophobic and racial slurs in Chicago, that wouldn't be investigated. Yeah. DeBatra says it makes a certain stupid level of sense that an actor would assume that Hollywood's version of Get Out technicality is reality. Well, they're nowhere close to it, even remotely. I do like the fact that there's no proximate cause here. He filed a police report and the police investigated. I mean, that's so attenuated. Those two things have no causal connection between each other because the police have discretion. They didn't have to investigate. Lord. F person. So yeah, he's trying to say there's no way to know a police report would result in investigation. Apparently. Lord. Yeah, police have no obligation to do anything, but yeah. So let me get this straight. Just let's even move past this. The police have no obligation to do anything. Therefore, under Jussie's theory, apparently anyone can make a lie up to the police at any time. You can just totally lie to the police at any time because actually this completely undermines the entire theory of obstruction of justice because, you could just tell the police a lie at any time, but they don't have any obligation to believe you. They don't have an obligation to believe anything you say or follow anything you say. So you can just report crimes that never happened. You can lie to the police anytime. So there's no such thing as obstruction of justice because it's not like because you told a lie, the police were going to do something. I mean, they still have discretion to do something. I mean, obstruction of justice, that implies that because you told a lie, that they were going to act on that lie. I mean, what a silly idea that is. So I guess the entire idea of obstruction of justice is dead. So I wonder what Jussie Smollett thinks about the idea of Trump committing obstruction of justice. I wonder if Jussie Smollett thinks that Trump should be indicted on obstruction of justice because, after all, assuming Trump obstructed justice, well, apparently that's not a thing anymore. Because, the FBI and the attorneys had no obligation to consider anything he said. I mean, they could do anything they want. So it's not like his lies are because of those, they would necessarily do anything. I mean, I guess Jussie Smollett thinks the president shouldn't be impeached. Who knew? Yeah, they don't need to prove anything. F person says they don't need to prove proximate cause. They need to allege proximate cause. Yeah, basically they need to say the actual cause and there's proximate cause. It's because of this and it's close enough. It's like one step removed. It's close enough for me. Lynn says, I think Kurt might stroke out. I'm pretty sure I did strike out at some point during this. Hollywood makes people insane. I guess. correlation does not equal causation. That's true. That's a fair point. Just because two things happen, doesn't mean that it was causal. I mean, it wasn't causal. I mean, it's not like because the report was filed, they had to investigate. I mean, they could have done nothing. It's not causal. Whatever. F person says, "Ha, you believe me? What fools you are." That's about right. I feel sorry for this guy's lawyer too. I will give notes for their lawyer, and as always, I not begrudge their lawyers. Their lawyers are presented with truly horrific facts and truly horrific law, and they can't spin outrage because their client is a douchebag. So, when you have the facts, when you don't have the facts, plead the law. When you don't have the law, plead the facts. When you have neither, I guess bang the table. But you can't bang the table because our client's an asshole. So I guess grasp at straws is all we got left. I don't know anything about the investigation, and the prosecutor let him walk. I believe the criminal prosecutor... last I heard, they were having trouble finding a criminal prosecutor. And so I don't know... because they reinstated the criminal charges or said they could, they appointed a special prosecutor. Last I heard, they were having trouble finding one. So I don't know if they actually appointed one or not at this point. Yeah. Lynn says, unclear where and to whom. What? Yeah, it's like, well, I don't know. It could have been anybody. Lord. It's a little bit Wookiee defense, yes. Carlos Maza, yes, it is a little bit that, yes. Some statements were made at the apartment. We have no idea. Those are just some statements, and it's not like those statements were. Oh, and as I remember from the 30 seconds of body cam tape until Jussie asked them to turn it off, he was wearing the noose when the police walked in. So apparently, that. And normally, that does not qualify as something the police would say. Geez, you seem to have this rope tied around a noose around your neck. And, yeah, wow. Yeah. 3 statements is numerous. It is a number. That's why I said F person, right? It is a number. Lord, was it painful to read as it was to watch? It was pretty painful. Yes, it was. Oh man, could you not tell that I stroked out at several parts in this live stream? Was that not clear? Did you not feel the stroking? Because I stroked out pretty hard. Yeah, they misworded it, so it should be dismissed with prejudice. So, can I just look at this as a judge? This is where I, as a judge, would just want to write an order that says "lol no." It's like, can I do that, or is that just I mean, technically, I guess I can, but it's like, I just want to be like, lol, no. It's like, do I have to really take this seriously? This is not worthy of my time. It's like literally not worthy of my time. Just write lol, no. Yeah. Quick, get an epidural. I don't know what I need. I think it's possible I died somewhere in the middle of the stream, and I'm no longer alive. Because it's like, this is, I guess I will give points. I will give 2 items a point. First, they did get one thing right on the double damages thing. It's totally premature because I don't necessarily have to pick one at this stage. I can go forward on all of them, and ultimately I might only be able to recover on one. That's totally fair, but it's way premature. But at least they made a legally valid point. It's a premature point, and if they could win it now, that'd be great, because then one would be dismissed with prejudice, and if they win the other one, then they just win, which is exactly why they won't get it. But at least they tried, and they said something. So in 12 pages, they said one legally valid thing. That was good. And in the other 11.9 pages, they desperately tried to grasp at straws with nothing to work with. I mean, these attorneys are making, I guess, $500 an hour. And this is what they came up with. And when you have nothing, this is what you write. Because you get nothing. It is just Unbelievable. Wow. Well, I'm so happy that 21 of you joined me for this stream. You were here to join me in watching me lose my mind once again to the story which will never die, because this civil suit is going to ungo. At some point, the criminal thing is going to ungo. I would anticipate there will be criminal charges. Potentially, the ones that were dismissed will come back. And then we'll have a wonderful double jeopardy fight. That'll be entertaining. And that'll go up through levels of appeal. And the whole thing is just like, it will never die. It's just like, yeah. 5K a day attorneys? Yeah, about that. Probably. Yeah. It's like, wow. This whole thing is... I can't... And the fact that he still wants to claim he's innocent is just great, too. Mr. Smollett disputes any assertions he made a false statement and was not a victim of a crime. You know... I want to... I wonder how much I can read into the very precise wording of that statement, because attorneys are not allowed to lie. Attorneys can't make representations that are false. So let's just assume that all this is made up. And let's assume Mr. Smollett actually told his attorneys that it was made up. So let's read this wording and see if we can tease out a precision in the wording. It says, Mr. Smollett disputes any and all assertions that he made a false statement and was not the victim of a crime. That's not quite the same thing as saying Mr. Smollett did not make a false statement and was not the victim of a crime. Mr. Smollett disputes it. Now that's a true statement. He does dispute it. But it's not quite the same thing as saying it didn't happen. So I wonder if this is very carefully worded to avoid making a false statement. Because it is true that he disputes it. It may not be true that it didn't happen. So they didn't say, to ensure nothing is misconstrued, Mr. Smollett did not make a false statement and he was the victim of a crime. They didn't write it that way. They say he disputes that he made a false statement and was not the victim. So I'm wondering if that's worded that way because his attorneys, being ethical attorneys, had to word it that way. And I wonder if we can tease out that from that precise level of wording. Do I believe Kamala Harris told Jussie to do it? Not particularly. I assume this was Jussie's idea all amongst itself. And even if someone had a casual conversation with him, I could imagine that Jussie had a conversation with someone and he said, I should totally do this. And someone said, ha ha ha, yeah, you should totally do it, as a joke. But I don't believe anyone but him really did it. I don't believe this is a conspiracy. Now you want to talk about Epstein? We can talk about Epstein conspiracies. I don't believe this is a conspiracy. I believe this is one guy being a total jackass. Were the other footnotes? Nope. That's it. Very, very exciting. Camilla Harris and Bookie were trying to push the anti-lynching bill through at the same time. Yeah, that's true. It was timing. And, of course, Camilla Harris and Cory Booker, I believe, both came out and said something like this is modern-day lynching and stuff like that. But I don't believe that there was a conspiracy between Camilla Harris and Jussie Smollett. It's possible Jussie. I could even foresee a potential situation where Jussie had a conversation with one of those two individuals, and they said it as a joke. But I am not gonna hold Camilla Harris or Cory Booker liable for a joke, or anyone else for that matter. If he had a conversation with someone, and he's like, I should totally do this to get money, and they're like, ha, you totally should. That's not a conspiracy. It's not a meeting of the minds. So I don't believe it happened. Even if it did happen, it was a joke. I don't believe in conspiracy. I totally think this is Jussie just being Jussie. And yeah, coincidence. Coincidence is my preferred theory. I try not to go into the conspiracy theories. I try to look for simpler explanations. Epstein is a whole other issue because the simpler explanations are not the simplest ones, and so it's like, yeah. Oh, I have no problem believing they were seen together. Yeah, I mean, look, I have no problem believing they know each other. And Jussie was apparently fairly good friends with, what was it, the former chief of staff for Hillary Clinton or something like that. And so there was suggestion that there was a suggestion that Hillary Clinton's former chief of staff had pressured the Illinois attorney to drop the charges. So look, I have no problem believing that Jussie knew Kamala Harris or Cory Booker or these other people. I'm not going conspiracy on this one because, I mean, no. Because not for least of reasons, Kamala Harris is not that stupid. She has many other problems, but she's not stupid enough to like, I'd like this to do, could you fake this? I mean, no. She's not that stupid. There are other reasons not to like Kamala Harris. This is not one of them. His lawyer's address is expensive, yeah. Again, yeah, John Pond says Tina Chen was friends with the Mayor Rahm Emanuel's wife, Amy Rule. Yeah, sure. And had CNN done Lyman and Speed Dial. Yeah, all these things are true. Jussie Smollett was well connected. He was well connected to Hollywood and well connected to Washington. He knew Tina Chen, who was the chief of staff for Hillary Clinton. He was seen with Kamala Harris. So like, yeah, I'm sure that like he ran in these circles. Same thing with Epstein, and where he ran a lot of these circles. I have no problem believing that they ran the circles. But this is like stupid on levels that I just have a hard time believing anyone would take their heads with. Because it's hard. I mean, it's just completely poorly planned on any level. It had like really no thought put into it at all. And like it was just like massively poorly thought through. So it's like, yeah, just amazing. So I hope this was interesting. It's been 56 minutes for 12 pages of, I can't believe that we're having this argument. But as further things happen in the civil case and further things happen in the criminal case, and God hope I think there will be further things in the criminal case. You know, I don't know the full implications of the law, but man, oh man, I really hope someday there's going to be some kind of justice, because this thing is like, yeah, whatever. Jussie did this whole thing for a raise? Probably, yes, sure, he did. I think interesting is a word for it, sure. Yeah. Yeah. I mean the anti-lynching thing, just to be fair, is just part of her presidential campaign. And, you know, the idea that like the white nationalism is a problem or like racial hate crimes is a problem is just a general like motif within like Democratic circles. So, I mean, the idea that she proposed anti-lynching legislation and the anti-gay lynching legislation as she was beginning to ramp up her presidential campaign doesn't strike me as odd. Maybe Jussie was aware of it, and if you want to like, maybe he was aware of it and decided to pull it off as a favor to her. But, you know, I'm not buying the conspiracy theory on that one. Not right now. You know, when both the cameras go off on Epstein's cell and both guards fall asleep, and he was in solitary confinement, but then he wasn't, and yeah, and he had this super plea hard deal and all bunch of stuff. That is much more triggering of my conspiracy bells than this one. But yeah, whatever. Did Epstein fake his death? I mean, there are four possibilities, right? When it comes to Epstein, there are four possibilities. Possibility one is he was murdered. Possibility number two is that he committed suicide. Possibility number three is that he was allowed to commit suicide. That people facilitated his ability to commit suicide. And possibility number four is he's not actually dead. Of these four possibilities, the one where he just committed suicide on his own initiative without any help strikes me as the least plausible. Up to even the fact that he's not actually dead is more possible. Now, that would involve a lot of conspiracy at this point, but yeah. I think allowed to commit suicide. My current leading theory is the suicide was facilitated. My current leading theory is that He committed suicide, but the tools and means were given to him. I don't think it was a coincidence that the cameras were put off. I don't think it was a coincidence that both guards weren't paying attention. I don't think it was a coincidence that he was transferred off suicide watch just before this whole thing occurred. So my current leading theory in my mind is the suicide was futility. So I'm going with option number 3. The neck being broken in 3 places, I agree, is super suspicious. I really, really hope that we're going to get a copy of the actual autopsy. His lawyers are challenging the whole thing. So hopefully they'll challenge it. Hopefully we'll get a copy of the autopsy. And we will definitely read that if we ever do. And we'll try to see if that gives us more evidence. But, yeah, the whole thing is just unbelievable. Yeah, it's just unbelievable. But the idea that he might have faked his death is not impossible. There have been rumors for years that he was tied to intelligence. Acosta himself, the former labor secretary, former U.S. attorney for Florida, who gave him that sweetheart deal, had said that that Epstein was intelligence. So the idea that ours or another intelligence service faked his death is not impossible. If you think about how many people would actually have to be involved at faking his death, it's not that many people would have to be involved. So it's not impossible. But the idea that he just somehow got the means to commit suicide through what would be the worst comedy of errors of all time strikes me as implausible. It strikes me as much more plausible if someone facilitated it. But that's where I'm standing right now. Anyways, that's all for now. I hope this has been helpful. We will definitely have more Jussie Smollett / Juicy Smollett in the future. If you have not seen the Dave Chappelle Sticks and Stones Netflix special, I highly recommend it. It is very good entertainment. Until later, my friends, cheers and goodbye.